Hi, good afternoon, everybody. We're going to get started on today's webinar. Thanks for joining us. This is the webinar, Raising Capital, Options for Small Business Government Contractors. My name is John Williams. I'm a partner in the Polaro Mazda Government Contracts Group, and I'm very pleased to be joined today by Kimi Murakami. She's counsel in our Business and Corporate Group. Business and corporate and government contracting are two of our main practice groups at Polaro Mazda, along with labor and employment and litigation. Today's webinar is a great example of how our different practice groups work together to deliver comprehensive solutions for our clients. The marriage of corporate and government contracting is particularly important for small business contractors because the corporate decisions that you make are so often affected by the regulatory environment that you operate in doing business with the federal government. So we hope that the webinar is going to be of great use for you today, and thank you for joining us. A couple of other housekeeping issues before we get rolling. Everybody will get a copy of the slides emailed to you after the presentation, so I know that's a common question, but we'll make sure that everybody gets a copy. And speaking of questions, if you have any questions throughout the webinar, please don't hesitate to use the question box and fire away. We will answer as many as we can in real time during the webinar. We'll try to save some time at the end of the webinar to run through questions too. And if there's any that we can't get to during the webinar, we'll follow up with you afterwards by email. So don't be bashful. Please feel free to submit questions. And when we answer them during the webinar, we will not say who's asking the question, so you don't have to worry about that. All right. So with that, let's get started on today's webinar. And this is an overview of where we're going to go. We're going to talk about options for raising capital for small businesses. You know, we're the lawyers. We're not bankers or investors, but our corporate group has a deep understanding of the options that small contractors have when they need to raise capital, because we've helped many of our clients navigate these issues. So the idea is to share some of our real world experiences, and that's what Kimi's going to do, because this is a big part of Kimi's practice, and I'm going to turn it over to her in just a moment to share with you her real world experiences, some pros, some cons, some tips when you're working through bank financing or you're looking at factoring and SBA loans and financing from private parties. So we want you to have a good understanding of what those options are and how you can navigate them from the legal perspective. And then I'm going to jump in towards the end and talk about how these options that you have at your disposal, as Kimi will discuss, can affect your small business status for government contracting, because depending on how they're put together, they can have affiliation implications. And so we always want to be very mindful of affiliation implications, the effect on your small business status when you're raising capital. And so that's what I'll bring in. And then we're going to end with, I'm going to bounce it back to Kimi. We're going to give you a little teaser on small business investment companies, or SBICs. This is a really unique way to raise capital, special for small business government contractors. We're going to just give you a little tease today, because we have another webinar we're going to do on October 25th, all about SBICs. So my hope is that we're going to whet your appetite today on SBICs, and you're going to want to come back and join us on October 25th to learn more about SBICs. All right, so importance of raising capital. I mean, this might seem pretty obvious, but it's a critical part of your business. You're going to need to do it to run your company, to expand your business. From my perspective in government contracting, it's important because financial wherewithal can be a factor in whether you win or lose a contract. You know, it is often a factor that's used in assessing a bidder. It's an element of responsibility as a contractor. It can be the difference between getting into small business programs, 8A program. Are you affiliated? Are you truly a small business? And I'll turn it over to Kimi, but you know, the managing the float, being able to weather the storm, these are critical concerns, Kimi, that I think you see all the time when contractors are coming to you asking for help to navigate these issues, right?
Right. It's very unique for government contractors um, how you're going to be able to access the capital because sometimes things happen in your particular industry very suddenly. When you're awarded a contract, for example, it's very cash intensive at that time for you to get up and running. You need to hire the employees and put everything in place. So being able to access capital is very critical to being able to perform that contract and to get going. Also, it's great having the government as your customer, but having the government as your customer, you also have to be able to deal with what happens politically sometimes. There's spending delays, there's sequestration. So sometimes the government's payment cycle may not align with your cycles. So it's very, very important for you to have some access to capital. Also, someone had raised a question about um, succession planning. And again, this is another time when you want to be able to have enough money or how you're going to handle succession planning. You need to put financing in place for that. Of course, you might have key man insurance already, but planning and having a succession plan in place to account for how you're going to raise that capital, maybe payment terms for how it will be paid back is also very important. And again, as John mentioned, we're going to try and cover some of your questions live time here, but I'll also be getting back to some of you on some of your other questions as well. So let's get started on some of the options that are available, the different financing options that we're going to present today. And as John mentioned, we're not recommending any of these particular financing options. We're just trying to present them to you so you'll be aware of them and have some idea of when you're talking to banks and some of the things you need to do to get ready for getting a loan. So loans can be structured either as debt financing or equity financing. Debt financing is where you will be getting the loan without having to give up any ownership in your company. And of course, we're always advising you to be very reluctant about giving up any ownership in your company. So that's what debt financing is about, and I'm going to be going through different options and getting debt financing. Equity financing, on the other hand, is where you will be giving ownership to an investor. And we're going to be getting into the impact that that might have on you as a government contractor that John is going to touch upon in the second half of this presentation. So you can get loans either from traditional lenders like banks or financial institutions. And we can also see often in our practices that you get loans from private parties, from different individuals. And we're going to talk a little bit about that and how that can affect you as a government contractor as well. And each of these different types of financings can have pros and cons or advantages and disadvantages, and particularly when viewed through the lens of a small business government contractor, as of course we view all of the business and different corporate transactions that you might enter into, we always have our eye out to see and make sure that it's not going to jeopardize your small business size status or trigger affiliation, which John is going to get into more in a bit. So one option for financing is to go the route of getting traditional bank financing. This is debt financing. Of course, the bank is not getting any ownership in your company when they're making you a loan. And for small business contractors, we customarily see the bank loans that our clients get as being a loan or a line of credit that's going to be secured by some of your assets. This is known in bank speak, if you will, as asset-based lending. And the collateral that they're going to be evaluating and use to secure the loan, generally for most of our clients, they're going to create a lien on all of your assets. That's known as a blanket lien. Sometimes they will look at certain assets and decide to perfect a security interest in just certain assets. This can include, of course, your accounts receivable, your inventory, some of your equipment, maybe some IP rights that you have. And in order to get a bank loan, you need to be well established. You have to have good credit. You have to have valuable assets. And so largely the bank is going to be looking at your credit worthiness. So some of the advantages and disadvantages of getting a bank loan, of course, now you have the money to be able to weather the storm, as John described it, to manage the float and fund some of your strategic operations and growth. Another advantage of getting a bank loan is that you haven't given up any of your equity. you still have all of the ownership in your company. Generally, as John's going to describe, there's less risk of affiliation if done properly, of course, in getting a bank loan. The disadvantages is that you have to be bank ready. And what we mean by that is you need to get your corporate housekeeping in order and really present a good story, if you will, when you're going to the bank. And I'm going to touch a little bit more about different things that you can do to get bank ready. The disadvantage also is now you might have a lien on some of your assets or all of your assets if it's a blanket lien. So they're encumbered. And so that's something to keep in mind. And as well, if the bank has determined that maybe you're a little bit of a higher risk, they might ask for personal guarantees. And so that, again, is another factor that has to be taken into consideration because now you might have a lien on some of your own individual personal assets. And it can have an impact or be impacted as well by other debt that you might already have. So if you're going to a bank and you already have a lien on some of your other assets, they're going to have to be in second place in the priority line, if you will, and the debt that they're going to give you will have to be subordinated. So these are other factors that we take into consideration and we can work through with you when you're going to get a bank loan. So some other tips that we have found when pursuing bank financing is you have to present your story in a way that demonstrates strong creditworthiness. You want to be a good risk. To do so, you want to make sure that all of your corporate records are up to date, that there's a clear chain of title in the ownership of your company. You have complete financial statements, you have a strong management team in place, you have a solid business plan which shows how your company would achieve its goals and use the loan that you're going to be getting from the bank. You want to have valuable and quality collateral that's not encumbered already. And you want to have the financial resources, if necessary, if you have to guarantee the loan that your company is going to be getting. You also want to make sure that you shop around for the right lender. Of course, when you're looking around, you do have choices, and competition can breed better terms for you. And keep in mind that you can negotiate. Even though the bank is on the other side and you don't have a lot of wiggle room, if you will, and you don't have a lot of leverage, you still can negotiate. So I just want to remind everybody about that because sometimes you go forward with getting a bank loan with maybe without asking us, so asking your lawyers. I just want to point out that you do have the ability to negotiate. And of course, your leverage is greatest at the time when you're first entering into your negotiations or looking for your bank because they want to get your business. So you do have a little bit more leverage at that point. Some of the terms you want to keep in mind when you're negotiating with a bank is you want to make sure you're not going to be automatically in default if you fail to make payment in a timely manner. Instead, you want to make sure that there's perhaps a provision where you would get advance written notice that you've defaulted on your loan, you're a few days late. You want to also ask for cure periods, so you'd have a few days in order to be able to realize that you're late and make that payment. You also want to make sure that the terms are terms that you can live with. Financial covenants, for example, there are going to be coverage ratios, debt to equity ratios that the bank is going to require. And you want to make sure that those are provisions that you can live with. You want to also have carve-outs for anticipated activities. So even though you really want this loan and you need this money, try and be thinking a little bit long-term of other things that you have on the horizon that you want to do, so you don't box yourself in too tightly in getting this loan. You also want to have a right to prepay the loan without penalties or early termination fees. So these are all the kinds of things we want you to keep in mind when you're thinking about getting bank financing or bank loans. So another product or financing option that's out there for small business government contractors is something called factoring. This is also known as accounts receivable financing. Again, this is something that you're going to be getting from the bank, so it's debt financing. And this is where the financial institution is going to buy the borrower's accounts receivable. In your case, as government contractors, that means they're looking at the creditworthiness of the government and that they're going to be getting the AR from the government making payments. So this product of factoring is not available and offered by all banks, but for certain banks that offer this product, John and I have seen in our practice that it is something that works out well for certain government contractors who maybe don't have the credit worthiness or they're not strong enough possibly to get a loan, a traditional bank loan. So again, some of the advantages, and we're not recommending these types of products, but just based upon seeing the feedback for our clients, that in getting factoring put in place, it's relatively quick. It's a way to get capital to maybe fund a contract if you're not necessarily bank ready. It's a way because you realize that maybe the way the government is paying, you're not able to have the cash flow to make payments to your employees. It's a way to put some financing in place to meet some of those needs that you're finding you have. The disadvantages, of course, are that you no longer own your accounts receivable, and because you're a government contractor, you have to go through what's known as the assignment of claims process. And also, this kind of factoring arrangement can be a little bit more expensive. I mentioned assignment of claims, and we bring it up here because in order to put this type of financing in place, in order to assign your accounts receivable that you receive from the government, you have to use the assignment of claims process, which is set forth in the law. You have to get the approval of the government for the contractor to assign its rights to payment in a case like this, and there are certain documents that have to be completed and signed by the government. Many banks have the forms of these assignment of claims documents, but again, this is set forth in the statute, and it's not something that we can negotiate. A lockbox account is set up at the bank to receive payments from the government, and it's a special procedure that's put in place, and banks that use this kind of financing or offer this kind of product are very familiar with how to set this up. We also, John and I just wanted to point out that some contracts expressly prohibit the assignment of claims. So this isn't an option available to everyone. But again, if you find that you might have to turn to this kind of product, it's something that we're very familiar with looking at your contracts and being able to determine whether or not this will be an option.
Yeah, I mean, it's like so many other things when you're doing corporate transactions that you've got to check your contracts. I mean, it's really important to understand whether you can do what you want to do or whether you can, you have to follow certain rules in the transaction you want to do. And this particular type of corporate transaction, factoring and assigning of your rights to payment on your invoices is very common in the government space, as Kimi mentioned. I mean, we see it a lot, particularly with newer contractors that are just getting started. But we just want you to be aware that some contracts might contain this clause. And if they do contain this clause, 52.232-24, that means the agency has already made a judgment that that particular contract should not be assignable, the rights to payment. So, I'm not saying that you couldn't still potentially try to work something out with them, but if that clause is in the contract, you're going to have a big hurdle.
And another product we just wanted to touch upon too is, so we've talked about getting traditional bank financing, a bank loan or a bank line of credit. We talked about maybe turning to a factoring type arrangement in certain cases. And another option might be looking to the SBA's business loan programs. Some banks make loans under the SBA's program. The SBA 7A loan program is the primary business loan program, and we've seen a lot of these come through recently, and we've worked on quite a few of them. These are loans that come from a bank, but they're guaranteed by the SBA. Again, this is a product that might be used in a case where a particular borrower doesn't have the liquidity that because they're a nascent company. They're a startup, for example, and they don't have the credit worthiness that maybe a contractor that's been in business a longer period of time might have. And they need money in order to do something, for example, buy certain contracts or buy certain assets or buy another company, like another contractor they want to acquire. And so in certain cases, certain banks offer a a bank loan under the 7A loan program that's guaranteed by the SBA. Now, in doing these kinds of loans, there are certain regulations that are imposed on the payment terms, for example, or how the financing is structured. Some of these, sometimes when we've looked at and worked on some of these products, if you're not familiar with them, you can wonder, why is the bank imposing this on me? There is a larger seller finance piece, for example. There's a 24-month standstill provision. So there are other kinds of regulations that are involved because, again, this is under the SBA 7A loan program. But we've seen this be a product that is definitely one that some of our clients have used very successfully. So it's just another option that we're putting out there to make you more familiar with. So we've talked about getting debt financing or getting loans from banks, and now we're going to talk about financing from private parties. These could be from friends, family, other businesses, other companies, maybe a business partner, angel investors, and this is very common, Jonathan and I have seen, for small business government contractors to maybe get a loan from private individuals. Loans from private parties can be structured either as debt financing, so the individual is not getting any ownership in your company, or often there could be a piece where the private individual who's making the loan is actually going to get some ownership in your company, and that's known as equity financing, or you're getting a private equity investor. As John and I are going to discuss in more detail now, having maybe a private equity investor who's going to now have a minority interest, for example, in your company, that can impact you as a small business government contractor because of the other regulations that you have to abide by. So that's something more that John's going to go into more detail about. But one of you had asked a question about that. What are the pros and cons of having equity financing? And if you're a small business government contractor, the big disadvantage or con, if you will, is the impact it could have on your size status, and it could trigger affiliation. So that's something we're going to get into more detail about. So as I just started to touch upon the pros and cons of doing getting an investor like a private individual, the advantages are, of course, it can be faster, it can be easier, simpler than going through what you've just gone through and trying to get a bank loan. There's a greater likelihood of being able to negotiate more favorable terms because hopefully these private investors might be more willing to give on certain things than a bank will be. And you didn't have to get your company totally bank ready, if you will, to be evaluated by a bank. But it's still a good idea to look at that list of tips that we gave you to make sure that you're ready when you're trying to present yourself and trying to convince someone to invest in your company. The disadvantages, as I just touched upon, is if you are going to give someone else ownership in your company in exchange for getting the loan, then you now have a minority investor, and what that impact is going to have. Because an investor is going to want to have a say in how you run your business. You have this new owner now who's now at the table with you. So there's a greater risk of affiliation that John's going to go into more detail about. So there are different options in how to structure getting involved with a private individual, if you will. You could simply have debt, and that could be evidenced by a promissory note. You're going to want to make sure, however, even if this is with some individual, just giving them commercial paper or a promissory note, that the terms are commercially reasonable terms. They should be arm's length. You have customary terms that you would in a promissory note with somebody else, such as an interest rate, that there are payment terms of whether it's going to be paid back monthly or quarterly or annually, that there's a maturity date when you're going to finally pay off this loan. The note could also be converted to equity. In other words, it could start off as debt, and then later on, when you pay it off, there might be an equity piece at the end. So if there's equity ownership or a private equity investor, how much ownership are you going to give? How is that going to be valued? And what class of ownership? Will there be voting or non-voting? Again, class, it raises a red flag for me whenever I see that, because if you're an S-Corp, as some of you are as small business government contractors, we can't have different classes of ownership for S corps. But again, voting and non-voting in most states will be okay and won't create those different classes. Also, what other rights are you going to have to give if you have a minority investor? And John's going to touch more upon this, because having a minority investor can create other problems and trigger affiliation issues. And also, is equity going to be pledged as security for repayment? So again, is this going to trigger some affiliation issues? And how is that going to impact your small business size status? So John is going to now, I'm going to turn it over to him so we can talk a little bit more about these affiliation issues.
Thank you, Kimi. Now, we did get a question here on this slide Kimi was just talking about. What's the most common form of non-voting equity ownership structure used by LLCs? I don't know if this is the most common form, but the one that immediately comes to mind that I've seen used a few times is just simply a Class A and Class B membership units, with the Class A membership units having voting rights and the Class B membership units not having voting rights. Kimi, have you seen similar? Or
Yeah, that's generally the most common form that we use. And again, by saying to you that we've used that before, I think it's telling you that we can structure it in a way that will work for small business government contractors without triggering affiliation problems.
Yeah, I think there's, generally speaking, a lot of flexibility when we talk about LLCs, especially. So, like Kimi said, I'm here now to talk about affiliation implications and everything that she just ran through. And this is the common way that it works between our two practice groups. Kimi is working on a deal in the corporate group. Maybe it's an M&A transaction. Maybe a client is looking to buy or sell, or that maybe it's a client that needs financing. They're working on getting a loan. And so Kimi wants to run by me and my colleagues in the government contracts group, are we going to have any adverse implications if we structure the deal the way that the business people would like to structure it? And so, that's a very common scenario for us, and we're trying always to get to yes. But understanding where the cones are that the regulatory cones we have to weave through, and sometimes that requires that we alter the terms of the transaction. Occasionally, it means that the whole thing just won't work, but we always want to be mindful of these potential implications, so that, because there is almost always a way that it can be structured to work within the regulatory requirements, and that's what we're trying. That's our objective, and that's how I think our groups work so well together. So, as just the basic starting point here, size matters. Obviously, if you are a small business government contractor, as I assume most of you listening are, your small business status is one of your most important company assets. So you need to protect it, because it gives you access to these special programs and set aside contracts, etc. If you are affiliated with another business, and that's a term of art in SBA regulations, affiliation. If SBA thinks you're affiliated, that can cause you to lose your small business status. SBA finds affiliation when one company has the power to control another, or when both firms are controlled by a third party. And they have rules. There are various ways they can find that one company has the power to control the other. If they find you affiliated with another business, they're going to add the revenues or employees of your company with your affiliate in determining whether you're a small business. So, real world example, you may be small on your own, $5 million a year in average revenue, but if you're affiliated with Lockheed Martin in the eyes of SBA, you are not a small business, because the combination of your revenues plus Lockheed's is going to push you well above the small business standard. And small business standards vary by industry, but none of the standards are high enough that you could survive affiliation with a business that large. And even if you're not affiliated with Lockheed Martin, you could be affiliated with your brother's company, and you're both doing $5 million a year, but the combination of the two could push you over your size standard. So you can see how it can really wreck your small business status if you have affiliation. And because small business status is so critical to all of the small business programs, then obviously if you have an affiliation that creates a problem on your small business status, that in turn is going to create a problem for your 8A eligibility, your hub zone eligibility, your SDVOSB, your woman-owned status. And this notion of control also presents a problem for those programs as well, because in those programs, the eligibility criteria are based largely on the majority owner's control over the business, whether that's the veteran's control over the business or the woman's control over the business, et cetera. And so if you have an affiliation issue, you have a control issue, you could have a problem. Even if it doesn't create a small business problem, it may create an issue for your woman-owned control or your vet-owned control, et cetera. So really critical, underlying issues here for affiliation. And so then how does this work with the different financing options that Kimi just ran through? I'll start off by talking about loans. So affiliation through loans. In most cases, the existence of the loan itself should not cause an affiliation. The SBA case law is pretty clear on this point that, if a loan in and of itself created an affiliation, then no small business could go anywhere to get financing, and that's crazy. So fortunately, the loan in and of itself isn't going to create a problem, but there is a but. The terms of the loan might present a problem. So we really, when we're talking about does a loan create affiliation, one of my first questions to the client is, I need to see the terms of the loan. Is this a typical arm's length, commercially reasonable loan arrangement, or is there something extraordinary about it? Is it not in writing? Very favorable, sweetheart terms, no interest, or you can insert the crazy terms here, but that's the point. Does it look like a typical note, or is it atypical? And the concept of commercial reasonableness, frankly, is not very well defined. I think there's an element of that that's in the eye of the beholder, but what you're looking to try to establish to the SBA is that there is some commercial market for this against which you can judge the terms of your arrangement. And that is harder to do when we're talking about a loan from a private party. And that's why Kimi mentioned that you have a greater risk of affiliation when we're talking about loans from a private party rather than a loan from a traditional lender, because it's harder to establish the commercial reasonableness of the loan from the private party. It's not impossible, but there can be, SBA might have a little more skepticism about that transaction as opposed to a loan or a line of credit from a traditional bank. Stock pledges and other types of security for loans are generally permissible. That would be commercially reasonable. In fact, I had one case where SBA questioned the lack of security, saying the fact that there wasn't security made it commercially unreasonable, because you ordinarily would not get a loan without giving security interest. Now, I think we were able to defeat that argument because, as Kimi mentioned, in some cases when the company has other debt, that debt the loan has to be subordinated to the senior debt, and if you've got senior debt, they're the ones that get the security. The subordinated debt is not going to have security. It's not possible to, and it wouldn't be permitted under the terms of the senior debt and the subordination agreement. So, but again, the SBA, their initial perspective at least was to question the lack of security. So you can have security, and in some cases it's actually to your benefit to make sure that you do, or at least explain why you can't. Is the loan a normal commercial practice? Again, I put this in quotes because these are terms that aren't clearly defined, and frankly, I don't know that they're clearly understood within SBA, but they use these types of terms. Well, I don't know we're questioning this loan because it doesn't appear to be a normal commercial practice. And again, I think this comes up most often in the context of a loan from a private party, like not a traditional lender. You know, but it could be questioned. Frank, it could be raised with respect to any loan, depending on the terms and circumstances of the loan. You know, and that's a good opportunity for me to make the point that affiliation cases are almost always about the totality of the circumstances, and they really depend on the unique circumstances of the case. So, you know, what might be a normal commercial practice for one loan, you know, a different loan with different terms may not be viewed as a normal commercial practice. So it really depends on the specifics. But I think if you're getting it from a commercial lender, a bank, you know, you're more likely going to fall within normal commercial practice. You're just not going to have that question raised by SBA. There was a case once where the size of the loan compared to the firm's revenues indicated to SBA that the loan was not a normal commercial practice. I think the company had like $500,000 a year in annual revenue, and the minority owner, which was a larger business, had given the company like a multi-million-dollar loan that they were using to finance their ongoing operations. And the SBA viewed that as not a normal commercial practice, that it was the loan was so much larger than their revenues. And that's a good segue to the next point here, which is what is the purpose of the loan? That is often a factor that SBA considers in deciding whether they're comfortable with the loan or not. And I really think that's ultimately what these cases come down to a lot of times is SBA is trying to read between the lines. And do they feel like this loan arrangement is a true arm's length loan, debtor creditor relationship between two independent parties, or do they feel like it's sort of a sham and the one is giving money to the other and is really exerting influence and control through that debtor creditor relationship? So if you've got a one-time financial transaction such as a stock purchase, so you have a loan, let's say, that closes on a certain date, and at that closing date, it's a acquisition of stock. That's a one-time transaction, and so what the SBA that's less of a risk of affiliation, because what the cases say is that whatever leverage the lender may have had ended when they signed the note, and at that point, the parties' relationship and any control the lender might have is governed by the terms of the note. And if it's a written note and it's has customary terms, etc., then that's entitled to the presumption of enforceability. So we're not going to say this relationship is a sham if we have a legitimate arm's length note agreement that spells out the terms, and if the lender cannot control through the terms of that note, except in the event of a default, customary rights of a creditor, then that is going to carry less risk of affiliation. Where you have lending that is being used and depended on to continue the company's operations, day-to-day operational expenses, etc., that generally is going to carry a higher risk of affiliation, because the perception SBA is going to have is that that's ongoing financial assistance. So it wasn't a one-time transaction that rises and falls based on the terms of the documents at closing, but rather it's an ongoing relationship where the lender has the ability to influence ongoing operations of the business. In other words, if I need your money to operate my business on a day-to-day basis, then I can't help but let you influence me in how I run the business. I mean, that's the perception. So if you need financing, especially from a private party for ongoing financial assistance, you need to be mindful of that perception and trying to structure the arrangement to combat that perception, because that is a perception that SBA is likely to have. Another type of affiliation that's implicated when we're talking about raising capital is economic dependence. And there are economic dependence rules that affect both size and status eligibility. So we have an affiliation rule on economic dependence, and affiliation is for small business status. We also have, for example, veteran control rules. Whether or not a service-disabled veteran really controls her company can be impacted by whether there's a perception of economic dependence by the veteran on a non-veteran. So this is another way that this type of issue could affect both size and status. And they're really looking at whether one is providing critical financial assistance to the other, and that you couldn't operate without that financial assistance. Would you be a viable business without that financial assistance? In the affiliation context, economic dependence comes up most often. They're looking at that you're dependent on your revenues from one particular source of revenue. But loans can also, and guarantees, et cetera, for financing can also create an economic dependence. So if this is something that could be the case for you, then you need to be mindful of this and trying to combat that perception when you're structuring the relationship. Negative control. This is the next type of affiliation concern that's implicated by raising capital. And I would say this is probably the most common issue that comes up when we're looking at investments from venture capital firms and other sources of private investment. And it's totally reasonable. I completely understand where those investors are coming from. They want certain rights and protections for their investment. I don't think that anybody would debate that that's reasonable. Even the small businesses often are understanding and willing to give the investors those protections because they want the investment. The problem is that if you go too far with the rights and protections that you give to the investor, you can have a negative control problem. And negative control means that the minority owner, the investor, or maybe it's a director, has the right to veto or block the majority owner from taking action. So this could be, if the investor becomes a minority owner in your business, then maybe you have certain decisions that say the company cannot do A, B, C, or D unless all owners agree to that decision. So that type of provision means that the minority owner has negative control, because unless that minority owner is on board with the decision, it won't happen. And this could also be the case even if the investor doesn't take an ownership position but gets a seat on the board. If you have provisions that say all directors must agree before the company does A, B, C, or D, then the director from the investor has negative control over the company because they have to be on board before the company acts. So negative control affects all the different size and socioeconomic status programs, and I'd say it's going to be in your operating documents. This is most often where it's going to be a problem. Maybe it's in your quorum provision, which says that the company essentially can't hold a meeting to conduct business unless someone from the minority owner is present at the meeting. It could be in the voting provisions. That's what I was just describing earlier about certain decisions that can't be taken unless everybody agrees. Transfer restrictions on the ability of the majority owner to sell his or her shares to whomever she wants, whenever she wants, is an important consideration for these socioeconomic programs. But oftentimes investors will want to limit what the majority owner can do with his or her shares. So you have to watch out for those things. So here on the next slide, 23 here, we drill down a little bit more on negative control. There is not a bright line in the rules that says these types of decisions are okay for negative control and these decisions are not okay. So you don't want to take away from this slide that certain decisions are definitely okay and certain decisions are not. It's a totality of the circumstances determination. But what we have been able to develop from many of the cases over the years is a sense that when SBA is concerned about negative control, it is typically because the negative control pertains to day-to-day operational decisions. So there are cases that say, we don't want the minority owner, the investor, to have a veto power over hiring and firing of officers or setting of executive compensation or approval of a board member. But conversely, the cases indicate that if we're talking about extraordinary company decisions like dissolving the company or bringing on a new owner or going into a completely new line of business, those are the types of extraordinary, not day-to-day, but outside the norm type major decisions that SBA is going to be okay with the minority owner having a vote on, having a veto power over. And I want to just flag in particular for SDVOSBs and WOSBs, you have to be, if you're one of these companies, you have to be so careful about negative control. That there was just another SBA case very recently that confirmed their position on this, that if you're an SDVOSB, you can't have any veto powers in your documents. The veteran has to control all decisions. So you really can't mess around with protections for minority owners if you're an SDVOSB, or WOSB basically follows the same rules. So it makes it very challenging for companies in these programs to bring on minority investors. The minority investors have to be very flexible, trusting, comfortable, whatever you want to say, that to make the investment and yet not have the customary protections that you would have as an investor. The VA actually had proposed some rules about a year ago, which would have, the VA has its own SDVOSB program, and they had proposed some rules a little over a year ago that would have provided more protections for minority investors in SDVOSBs, which I thought was great. They recognized that they want veterans to be able to be a little bit easier for them to bring on investors and grow their businesses. But unfortunately, the VA just recently indicated that they're withdrawing that rule, so they're not going to move forward with it. And I don't know what SBA is going to do on this. Unfortunately, like I said, the recent case law indicates they're still taking this pretty harsh position on they're not being able to give rights to minority investors in SDVOSBs and WOSBs. Stock options, Kimi mentioned that you could have a loan that could be convertible to equity. You could also just give somebody an option, a stock option. If you're doing something like this, you need to be mindful that SBA has a rule called the present effect rule. And this rule says that the SBA is going to treat stock options and convertible securities and agreements to merge as if they've already occurred. They're going to treat those rights as if they've already been exercised. So what that means is if you own the majority interest in your business, but you've given somebody else a stock option that would make them the majority owner in your business, SBA very well may look at that arrangement and say, you're not the majority owner of your business because we're going to treat that stock option as if it's already been exercised and that other person is the majority owner. Now you can potentially avoid that if the stock option is remote, or I guess extremely remote. I should emphasize that. So there, can't be something that could be too easily exercised by the other party. So you want to be mindful of that if options are going to be on the table when you're raising capital. For these programs like 8A and HubZone and SDVOSB and WOSB, the ownership of the majority owner has to be unconditional. So we are always concerned about placing conditions on ownership. That this comes up most often with transfer restrictions, which I mentioned a few slides ago, that we need to be very careful about restricting the 8A owner or the woman or the veteran, the service disabled veteran owner, in their ability to transfer their stock to whomever they want, whenever they want. That includes rights of first refusal and tag along rights, which are extremely common, again, in Kimi's world when we're raising capital and doing corporate deals. Rights of first refusal and tag rights are very reasonable and typical. Unfortunately, when we're playing in the government space, and particularly as a small business contractor, some of these programs just aren't going to let you do that. So you have to be mindful of that as you're structuring the transaction if you participate in those programs. And just an ownership change can create an issue. I mean, not necessarily a fatal issue for your certification in a small business program, but if you bring on a new owner, you're going to likely have to go through some type of a vetting process for your small business certification. And that could be like, for example, 8A. If you're an 8A firm, you can't bring on a new owner without getting SBA to approve it first. If you're an SDVOSB certified by VA, you have to notify them within a certain amount of time after the ownership change, and then the VA is going to come in and re-verify whether you're still eligible for the program. So just be mindful that even if you're being very careful about negative control rights and stock options, et cetera, and your investor is only going to own 20%, so you're still going to have the unconditional 51%, you may have some notification requirements that you have to jump through, and just be prepared that the government's going to come look under the hood to make sure that you're still eligible after the ownership change. And then the last point that I want to make before I kick it back to Kimi for our little teaser on SBICs is using MentorProtege. So, I mean, this is really a game changer because we now, since about a year ago, have this new all small MentorProtege program, and I'm sure most of you have heard about it, hopefully participated in our webinars on it, and if you want more information about it, let Kimi and I know. We'd be happy to get it to you. But the reason that the MentorProtege program is so critical for what we're talking about today is that the MentorProtege program provides an exemption from affiliation between the mentor and the protege for the assistance provided under the mentor-protege agreement. So you cannot, as a protege, you can't be found affiliated with your mentor if the mentor is doing things to help you and you put that right in your mentor-protege agreement. So your mentor-protege agreement explicitly says, I'm going to provide financial assistance to my protege. Then they can't find you affiliated based on the financial assistance that's in your mentor-protege agreement. So if you're looking at raising capital, especially from private equity or private party or some type of, not just like a straightforward bank loan that you're getting on your own, I really think it's important to look at doing a mentor-protege relationship first. Do the loan arrangement, the financing arrangement, under cover of a mentor-protege relationship, so that it's explicitly approved by SBA. You're going to tell them up front, look, we're entering into this relationship and we're doing so because the protege needs to help raising capital. This is how we're going to do it. SBA, if they approve you, then you go ahead and do it. And I think that's the right way to do it. And this is a very useful tool now. This program is open to all small businesses, so any type of small business can do this. And it's, the program also envisions that the mentor might own up to 40% of the protege, which is it's another, facet in what Kimi was talking about. So then whether it's equity or debt-based financing, could be both. We can roll that into the mentor-protege program and get this affiliation exemption. So all the stuff I've been talking about about these affiliation implications, we can put a shield in place against all that if we have this mentor-protege relationship.
Okay, and so as John mentioned, we just wanted to bring up one teaser here that we can hopefully get you interested in, and we already had a question about SBICs, small business investment companies. And the reason this came up really and was the genesis for doing this webinar series was because, as John just went through half our webinar, doing private equity in the highly regulated government contract industry is challenging because you might face some of these affiliation issues. And so we started looking into the option of small business investment companies. And what are they? So SBICs are private investment funds, but they're licensed and regulated by the SBA. So it's kind of a unique public-private partnership here, where an investment fund, generally set up as a limited partnership, might raise some private equity, but then is able to avail itself, if it's a licensed SBIC, to certain funds that are available from the SBA, which are created due to investments by the SBA known as debentures. So SBICs can invest in small businesses within certain thresholds. Of course, this is a regulated area. And SBICs have invested over $20 billion in more than 11,000 domestic companies, including those that are very well known, such as Whole Foods, Federal Express, and others that I've listed there. So this is a very unique kind of opportunity of getting some equity investment through the use of SBICs. There are exemptions for SBICs. We've put some of those there as teasers for you. There's an affiliation exemption. There are some also unique 8A rules for small businesses that are owned by SBICs. So we hope you might be interested in learning more about SBICs, and will consider joining us on October 25th when we talk more about them. Okay, I think we have about 5 minutes left. We could start going through some of the questions that are posed. One of your questions is about whether or not we offer a service that matches potential investors with other small business targets. Sometimes that happens, and we do offer that service. I will say, as an M&A lawyer, sometimes when I've done some matchmaking, then both of you, I can't represent either of you if you decide you're a good match, because there's a conflict there, of course. So we can't represent both parties on either side of a transaction. So while sometimes we do, I don't want to say we provide that service, but sometimes.
Yeah, and we do have some. That is something that I think, like Kimi said, we can do it ad hoc between existing clients. That sometimes we'll have a client that comes to us and says, here's what I'm looking for, and then we can see which of our other clients might be interested in doing it. But we do also have people here that will help you sort of work up a list of what your market might look like and potential targets, but we're not an M&A advisory firm, if that's what you're driving at in your question. Somebody's asked, how is shadow stock viewed by the SBA? I think I have not heard the term shadow stock before, but what I've heard it referred to as is phantom equity, which I assume is the same thing you were referring to. So phantom stock is one way that you can compensate, I think it's often used to compensate longtime key employees, that you're not going to give them actual ownership, but you're going to give them phantom ownership, which allows them in some way to participate in the economic benefit that the company might reap in a sale, or the appreciation of the company's stock over time. I don't know if we have a clear sense of how SBA views it. I have, in the 8A context, heard that in the past they have wanted to look at phantom equity plans. I've always been of the view that it shouldn't have any impact on SBA because it's essentially just a compensation mechanism. It's not actually ownership. So from an ownership standpoint, it shouldn't affect how ownership is assessed, because it's not a separate class of ownership. That's a different issue. And there's another question here about having multiple classes of ownership, and is that a good way to protect against affiliation, that you have the voting ownership and the non-voting ownership. And since affiliation is about control, you're trying to insulate if you've got a particular owner that maybe you were worried about them having control, you give them only non-voting ownership. And I think that could be an effective strategy. I mean, again, it's going to depend on all the circumstances, and you have to also be careful that a lot of those socioeconomic programs require the disadvantaged individual or the veteran owner to own a majority of all classes of stock. So you may not be able, depending on what type of company you are, to simply create a second class of ownership and give all that ownership to somebody else. But generally speaking, that's a workable strategy to create a separate class of ownership and look at making sure the control is only in the one class. All right, I think we're going to land there because we're just about 3 o'clock. There's a few more questions we didn't get to. Sorry about that, but we will follow up with you via email. And if anybody didn't think of any now, but you think of one as soon as we hang up, feel free to email Kimi and email me. Our contact information is on the last slide here. It's also on our website, poleromaza.com. We thank you so much for joining us today, and we'll see you soon. Please join us again on October 25th. Thanks. Bye.